There is a new law going on the books in Massachusetts in the middle of the new year. New requirements for employers regarding sick leave time. Attorney Amelia Holstrom of the Springfield law firm of Skoler, Abbott, and Pressler is an employment law specialist. There are a lot of questions about the law that will take effect in 2015. Of course, that change came when Massachusetts voters approved Ballot Question 4 on Election Day in November. Attorney Holstrom, thanks for coming in, first of all. What kind of employer, who's impacted by this new law?
This is going to impact all employers in Massachusetts. Specifically, employers with 11 or more employees are going to be required to provide paid sick leave up to 40 hours per year. That is based on an accrual that accrues as is outlined in the statute, and that is going to be 1 hour for every 30 hours that the employee works. That's for an hourly employee. Employees with exempt employees are assumed to work 40 hours per week and will accrue on that basis unless they actually work less. And that will accrue at the rate of hours that they actually work, but it will still be 1 hour for every 30 hours that the employee works. Employers with less than 11 employees have to provide unpaid sick leave to employees up to 40 hours per year based on the same accrual rates as I just discussed.
It is, I know it's been a worry for employers. Many of the business organizations were pretty strong in their opposition to Ballot Question 4. Does any employee just walking in the door automatically get handed sick time, or they have to work for it, right? There has to be some time, as you mentioned.
The way it is going to work under the statute is employees begin to accrue this earned sick time, whether it be paid or unpaid, on July 1st of 2015, or their date of hire, whichever is later. But, however, they are not eligible to take that leave until they have been employed by the employer for 90 days. So someone who starts on May 30th of 2015 will begin to accrue on July 1st, but won't be eligible to take that leave until the end of August, after they've been there for 90 days. Someone who starts on July 2nd will begin to accrue immediately on July 2nd, but won't be eligible to take that leave until the end of September, when they've been employed there for 90 days.
You already mentioned this, but I think this is an area that confuses people. It was confusing in the write-ups about Ballot Question 4. If you are a smaller company, 11 employees or less, I believe, or under 11 employees, a lot of people have the impression, I don't have to worry about this. That's not exactly true, right? Right,
that is not true. If you have less than 11 employees, you have to provide unpaid sick leave up to 40 hours per year to your employees. And so you're going to have to allow them to accrue that leave, and you have to let them take that leave for qualifying reasons, but it does not have to be paid. It has to be unpaid. And that's if you have less than 11 employees.
And again, you accrue the time, but what about using the sick time? Again, there are some time requirements. You, again, don't just walk in July 15th and say, here I am, oh, I don't feel good, I'm taking the day off. It doesn't work that way.
Right, an employee has to be employed with the employer for 90 days before they're eligible to take the sick time, whether it be paid or unpaid. They can take it for various reasons, including the employee or the employee's spouse, child, parent, or parent-in-law's health condition or injury or illness. They can also take it to attend routine medical appointments for the employee, the employee's spouse, child, parent, or parent-in-law. And lastly, they can take it to address the effects, whether they be psychological, physical, or legal effects of domestic violence.
What about, now, we all like to think there's a great employer-employee relationship. And depending on what kind of job any of us are in, the professional positions or those maybe lower down the totem pole, there can be a great deal of difference. And let's be honest, we've all worked someplace where there was either a difficult boss or employer, or more often than not, a difficult employee. Someone who's always looking for the rule, the loophole, the way around things, and can really make a boss's or an office manager's life kind of miserable. Can an employer ask for a doctor's note or a pharmacy receipt, or can they ask for some proof of illness?
The statute limits when an employer can request certification for the need for leave, and that is limited to when an employee has used more than 24 consecutively scheduled work hours, and they've used that sick leave to cover their absence more than that 24 consecutive work hours. The employer can then ask for a document from a healthcare provider, and that just has to be a reasonable document. There's no definition as to what that is under the statute right now. And again, that's if someone has been used paid sick leave for more than 24 consecutively scheduled work hours. So,
whenever there's any kind of law or legal document that things aren't exactly specified, you know that can lead to hell for everybody involved, the bookkeeper, the HR person, whatever. Is that an area of the law that concerns you? Because you're going to represent employers, and we know probably shortly into this, somebody's going to sue somebody saying, I didn't get my rights to sick time that I deserve under this law.
It is concerning, but under the statute, the Massachusetts Attorney General can issue regulations, and those regulations are anticipated in January. And we are hoping that the Attorney General's office will address those concerns. But most importantly for employers, they should know that the statute prohibits retaliation against employees who exercise their rights under the statute. And that means that employers cannot consider the use of sick leave as a negative factor in any employment decisions, including disciplinary action, terminations, or even performance evaluations and promotions. So that's something that an employer needs to be aware of.
The idea of advance notice with sick time sounds kind of crazy, but if it's a doctor's appointment or something you know that's coming up, is there any requirement in the law that we're aware of for advance notice when you can of time you're going to use?
The law only requires for foreseeable leave that the employee make a good faith effort to give advance notice. And again, that's something that's undefined, so it's unclear right now if someone comes in at 8 in the morning and gives you notice of their physical that they've had scheduled for months in the afternoon, whether that will be sufficient advance notice. And again, we hope the Attorney General's regulations will address that.
What happens at this point to sick time accrued but not used at the end of a year? We know sometimes in some public employee contracts, you sometimes will get a portion of your unused sick time given to you in a lump sum of cash, perhaps, when you leave or retire. Is there anything like that in this law?
At the end of the year, the employee may carry over up to 40 hours of unused sick time to the following calendar year. That being said, an employer is only required to allow an employee to take 40 hours of sick time in that following calendar year. So in other words, if someone has been carrying over unused sick time for several years and they have 60 hours and they decide they want to use it in 2017, the employer only has to allow them to use up to 40 hours in that year, that calendar year.
It sounds like this is a kind of bookkeeping hell, especially for perhaps that, well, the large company's got its own problems. The smaller employer, where maybe it is a mom and pop shop, but they've got a dozen or so employees, so they've got to pay and they've got to keep track of a lot of different things. This is going to be a lot of responsibility for employers, it seems.
This is going to be a lot of responsibility, and they're going to have to be careful to make sure that everything accrues at the appropriate rate and they're allowing employees to take it for the reasons they're permitted to take it. And hopefully employers can find something in their payroll system that will enable them to keep track of it the same way they do with vacation time.
Do employers face sanctions or penalties if it's charged or it's found that they weren't complying with the law?
Yes, there are penalties outlined. The Massachusetts Attorney General's office is the mechanism for enforcing this law. So an employee would file a complaint there. After an investigation, the Attorney General's office can issue penalties such as a written warning or a civil fine. The civil fine can be up to $25,000 per violation. Additionally, they can require you to pay restitution to the employee, which could include backed wages, which could be a lot. If an employee was terminated for their use of leave, it could be however long they were out of work, or it could be just a few days if the employee is denied leave for just a few days. But that can certainly include back pay.
Well, Attorney Amelia Holstrom from Skoler, Abbott, and Presser, sounds like you'll be busy. Sounds like an interesting time ahead in employment law.
We will.
Thank you very much for coming in.
Thank you for having me.